Welcome to the Understanding Regulation Best Interest. I'd like to start by introducing Mike Kell, Senior Vice President of Business Development and Program Management. Mike?
Hey, Jen, thank you very much for the wonderful introduction, and certainly appreciate everyone joining the call today. We have a phenomenal audience, and certainly appreciate your time. Really, to kick off the call, I just want to say that here at AI Insight, we host all kinds of webinars, bring great valuable content to our subscriber base. And certainly every so often, it seems too often these days, we have significant regulatory undertakings. And we obviously like to bring some of that valuable information to the subscriber base as well. So this particular webinar, obviously Reg BI, significant thing in the industry. There's a lot of moving pieces. It impacts everybody's business on a wide spectrum of sides. So we partnered with the Bates Group on this particular webinar to bring some great insight into Reg BI. We're very well aware that a lot of you have been reading about Reg BI, have hopefully taken steps in the right direction specific to Reg BI. But I also know that there are many on the call that are maybe waited maybe a little too long and are trying to search now for more information as well as more resources. So we're really hoping this call brings some additional information to those that already know quite a bit about Reg BI, as well as some value-add information and even potential discussion of available resources for those broker-dealers, REAs, et cetera, who are on the call that might be a little bit later to the game as far as getting things started. I won't read the bios here on the screen, but suffice it to say, we have David, who's a managing director of Bates Group, member of the Bates compliance team, and Linda, who's a managing director of the Bates compliance team. Very vested individuals, very intelligent about what they do. The Bates Groups by themselves provide wonderful compliance-related services to the broker-dealer REA community. So a great resource. Absolutely happy to have them here. With no further ado, we look forward to the presentation.
So I guess that means that I'm up. This is David Birnbaum. First, thank you, Mike, and to all the folks at AI Insights for the opportunity to participate, and certainly for the professionalism that we've encountered when working with their folks. I'm not going to rehash who I am. You'll see that on the slide, and you can find me through Bates. I will say though that I don't look like that picture. All right. That picture was taken the evening before my daughter's wedding. And that's the happiest I've ever looked in my entire life, before or since. So the only other time you'll ever meet me when I look at that is when she has a baby. But other than that, I don't look like that. In any event, before I get rolling, Linda, do you want to introduce yourself or make any remarks?
So this is Linda Shirkey, and I want to thank you, AI Insights, for inviting us, and I look forward to your questions and only hope that we can answer them.
Okay, so the first slide just generally shows the topics that we're going to cover. Now, the interesting thing is that they don't really flow in this way, in this order, because by way of example, if you look at number 2 in new obligations, those will show up throughout. Right? Conflicts, compensation, and disclosure, number 5, also has a ton of new obligations. So this is generally what we're going to cover, but not necessarily in this order. We will try to touch on them a little bit in this order. The slides that you'll see are pretty dense. We're not going to read from them or cover all of them, all of the information in there. It's mostly for your reference. And we also took the opportunity to put reference information at the back. And if you are interested in reaching out to either me or to Linda, our contact information as well as others on the Bates team are in the back. Okay, let's dive in. So where did Reg BI come from? All right, so I think everybody really does know that if you go back to 2016, that was both the start of the rise and the fall of what became known as the DOL rule. The DOL rule at the time was a one-size-fits-all rule for broker-dealers and investment advisors. The focus was on the expansion, if you will, of ERISA to all retirement plan advice. And firms were even thinking about, well, how the heck do I divide up the way we do everything? Market, sales, supervision, compliance. How do reps divide up what they have to do based upon whether it was a retirement plan and retirement advice, or if it was, or not. Well, ultimately, that never came to be, right? It was vacated by the courts in March of 2018. Not going to rehash that, but I am going to say that the courts killing the DOL rule, was because the rule that was based on procedural grounds, essentially saying that the Department of Labor did not have the authority under law to do what it was trying to do. But lots of people liked the idea of doing what they were doing, but sort of the manner of its implementation and some of the specifics did not like. So along came the SEC to fill that gap, propelled by a lot of political push to fill that gap. And out of that came Reg BI. So what you're going to hear about Reg BI from Linda and I throughout are three major themes: compensation, conflicts, products, right? And the slides speak a lot to compliance and supervision and operations and technology. But given this audience, who is listening in on this webinar, we're going to sort of de-emphasize the compliance, supervision, and ops speak and tech speak. You know, that stuff we usually do when we go in to help a firm from soup to nuts implement Reg BI, but rather speak to topics we think that are more in your line of sight. And again, that takes us back to compensation, conflicts, and products. Okay, so you'll see what happened, April 18th, 2018, June 15th, 2019. What is happening is that the SEC is making its way to adopting Reg BI, right? What's the purpose of the Reg BI, as they say it? It's to allow for retail investors to get a greater knowledge and an understanding of who the firm is that they're hiring, who the individual is, the services that they're going to get, what's it going to cost, and how they're going to pay for them. It is not a rule which says, walk 3 feet, make a left. Walk 7 feet, make a right. You come to a fork in the road, do this or do that. It is not that way. It is more principles-based, and has a big, the biggest principle is, thou shalt not exist in conflict with thy client, right? So you either have to disclose it, mitigate it, or get rid of it. There are some prescriptions. They are few and far between. For example, they say no sales contests. Why no sales contests? Because they say that because they believe that it's a conflict that can't be mitigated. So the focus becomes, I should also say there is no real definition of what best interest means in the rule, in the guidelines. It really comes up as I said, as a principles base. The focus becomes identifying gaps and conflicts in the practices and procedures that we've all had as we've grown up in the industry. There are ambiguities in the rule. As I said, there's no definition to Reg BI, an actual definition, but those are in large part intentional, right? They allow us to fill the gaps, to find the gaps, and fortunately or unfortunately, depending on your view, they also allow the regulators to do that. So how is it different from what we have before? In many, many ways. In one very principal way, it expands the current suitability obligations that we all have, right? What is happening is that it essentially is saying now that broker-dealers cannot in any way either implicitly or explicitly put their interest before a customer's interest. It is also more expansive than the suitability rule in that it applies to things that suitability didn't apply to before. Rollovers, certain strategies, hold recommendations, and things like that. But again, go back to the basic principle. It's that firms and registered reps, associated persons, can't put their financial interests ahead of clients, either implicitly or explicitly, when making recommendations. So the rule itself is mostly interpretive guidance. about 700 pages of interpretive guidance. There are some pages, not a lot, of rules and reporting obligations. So how does it break down, right? So you'll see on the bottom of the slide, that first slide, it says disclosures, duty of care, and conflicts of interest. But because conflicts of interest, next slide please, because conflicts of interest actually show up virtually everywhere, we're going to start with there. And what I would say to you is that they apply to the firm and to individuals throughout. Linda, maybe you can talk a little bit about conflicts of interest.
So I think that I'm going to disagree a little bit with David in terms of the key elements of Reg BI, because I really think they are a combination of disclosure and conflicts. And Reg BI defines a conflict as an interest to incline a person to make a recommendation that is not disinterested, whether conscious or unconscious, which is the closest we're getting to any of the definitions in this reg. I think what happens is, especially in the broker-dealer world, you're not accustomed to thinking about the conflicts that are inherent in how the firm is offering products and how you are actually making decisions for clients. It's really difficult to see your own conflicts, and what you have to be able to do is think about the optics. So why are conflicts such a big deal, and why is this all coming up now? The regulators are really concentrating on the retail market, and partly as a result of the DOL rule, but partly as a result of Jay Clayton, who's the chair of the SEC Commission, is really focusing on the retail market. And with so much retirement money coming into play now, with all of the baby boomers retiring, they want to be sure that clients and prospective clients are making informed decisions and that they understand the possible incentives with recommendations, transactions, and changes that are occurring in their portfolios. So again, this keeps coming back to they want clients to be making an informed consent to any decisions that are being made on their behalf. So how do you determine what a conflict is? And the trick is to follow the money. And you look at where does the firm give incentives, and how does the firm benefit from sale of particular products or from any revenue streams they have? And then what happens to you at the personal level? Are there additional incentives for you at the personal level? And again, we talked about, so what we've done is we've given you a sort of laundry list here of potential conflicts of interest that could occur with a firm, whether a broker-dealer or an investment advisor. And on the lower right corner, we list conflicts that may be occurring at the individual side. So on the broker-dealer side, the broker-dealer is required to disclose conflicts at the firm level. And the registered rep is expected to disclose, not necessarily in writing, but disclose to a client if the registered rep has any conflicts as a result of the recommendation or transaction that is occurring at the time. And as David talked about, there are specific conflicts that the SEC has said these can't happen anymore, including sales contests, bonuses based on sales of particular products within a certain period of time. But there are other conflicts that are okay. A conflict doesn't mean it's necessarily bad. It just may mean that it needs to be mitigated and disclosed so that the client is coming in again with informed consent. So I've talked a little bit about the need for disclosures and need for discussion of conflicts of interest. Let's go to the next slide, and David, you're back on.
So that was helpful, really helpful. And when you go back to look at these slides, and if you look at that one in particular, I like it because, as Linda said, it's really a follow the money. There are different kinds of conflicts that come up all the time, but the one that the SEC is focusing on and that FINRA will enforce, use its enforcement power, are with respect to those that are money more than anything else. Okay, so what are the other obligations of Reg BI? We've already touched on them, interestingly enough. So disclosures, that broker-dealers will have to disclose material facts about the relationship with the client and any recommendations, fees, and services. Now, we've always disclosed fees. We've disclosed them on confirmations. We've disclosed them at times on ADVs for both broker-dealers who are both joint registrars or just even investment advisors. We've disclosed them in offering documents, but never like we're about to, right? We may have said there may be substantial fees or where clients will be charged, but now we're going to end up getting more specific. The other is to disclose the nature of the relationship with the clients and how are we acting, right? And we'll get to that too. And as it says, you'll see that third bullet point really does speak to the cost of services. Duty of care, I mentioned it above already, that it's similar to suitability, but more, right? So exercising reasonable diligence, care, and skill in making recommendations, rewards, risks, etc., operating in the manner with the suitability information you have. But there are a few more things now, ever before. So for the first time, really, is that you need to have a reasonable basis to believe that the recommendation is in the client's best interest, right? Now, that means a bunch of things that I can't get into all of it because this is all we'll talk about if I get into that, but it is an additional obligation on the firm and how they do that. And essentially, I can boil it down in one example. Why are certain products on the product shelf of the firm? Why are they there? And what we're seeing is firms start to, I'll use the word rationalize, which also means cut down the products that are offering and figuring out why they're offering. Why are they there, right? So we've seen firms, frankly, smaller firms mostly, but also even the largest firms. There's a lot of information about Goldman Sachs in this space, where they are offering product that they have a private product which they have a significant interest in. So it comes down to a duty of care of are firms, for example, or individuals favoring proprietary product. That's a good example of that. Also, the rule of the duty of care also requires broker-dealers, them to consider cost as part of the decision. Before, under the suitability rule, cost, essentially, you have to act in a fair, you have to have act fairly with respect to price and commissions. This goes further, that now cost and fees have to be a factor in a determination of what is being offered. The SEC has been asked in its Q&As, is it the main factor, the only factor? And the answer, frankly, has been no. But it also goes back to say it is an important factor. Conflicts of interest, really it comes down to, it's what we've said, what Linda was saying before. There are some things eliminated, sales contests, sales quotas, bonus and non-cash comp tied to specific securities and types of securities, but I think Linda's basically covered that. Next slide, please.
David,
so
can I just pop in
Sure.
for a second? Because I think
Sure.
it's important here to say that we're really focusing on the broker-dealer side here, but there's a parallel release that applies to investment advisors. And the changes that we're talking about are largely on the broker-dealer side, but there are going to be significant changes on the IA, on the investment advisor side as well. It's going to mean a lot more documentation in terms of collecting initial information on a client in a way that's really easily producible for exams. And there's much more emphasis on looking at the cost to the client initially when you make the investment, and then on an ongoing basis, so that Reg BI really applies to broker-dealers on a recommendation or transaction level. And what they're looking at on the investment advisor side is the entire relationship being managed on a fiduciary basis, which is a higher level of a higher standard than best interest. And how are you monitoring on assets that are already held to be sure that they're still the lowest cost and the best available to clients? So there's a little bit of a difference between the two, and I think that's not often discussed. I'm sorry. Go ahead, David.
No, that's fine. And let me just add to what you just said. So the notion of monitoring is a big deal, right? And whether the firms and the individuals undertake to continue to monitor. Also, in the nature of fiduciary duty for investment advisors, it's not product specific, as in you're offering an investment advisory product, but rather relationship. Overall, looking at it to see so you have a continuing obligation to monitor by way of examples. Okay, next slide really goes to the macro. And I'm not going to spend any real time on it, but just to give you an idea of some of the bigger challenges that firms and individuals, but mostly firms, are looking at. So, compensation. What is the type that we do now? Will it continue to be okay? Also, compensation and money with respect to products. And these are areas, disclosures, new compliance, increased cost distribution, compensation, where there will be significant change as a result. So take compensation for just a moment, right? So we're going to see more of a leveling of fees among products by way of example in compensation. Between products and among the different kinds of products. Grids and how grid and payment on a grid. A lot of firms are going to make a lot of changes here. Some firms are thinking about eliminating the grid altogether, but there's mostly a focus on making change to it, significant change. Favoring one type of product or another. Procedures that, from a compliance perspective of when approaching compensation thresholds. Forgivable loans. Right? So there's a whole lot of change, and that's the larger item. Next slide, please. We go to the next one. This actually drills down. I'm not going to take you through all of this. I can barely read it, but I am going to focus and just say to you that this deals with relationships and sort of what relationships are impacted by the rule. And if it, in essence, it is the client, the firm, the rep, and third parties. So if I look at these in that light, across the top, the two, those are impacts more on the firm. Now, it's not to say that if something impacts the firm that it doesn't impact the people within the firm and outside, but the primary impact would be on the firm. If you're going down on the right, one down, strategic initiatives, also the firm, all the way down, the customer experience and how we relate to our clients, right? When we touch on documents we deliver, things we say, right? I'm going to come back to that in a second. And then the revenue sharing with third parties, right? So we've heard a lot about C-shares and the like in the SEC and FINRA's initiatives recently, enforcement initiatives. Those are likely to go away in large part. They're going to change dramatically. And then registered rep, and the compensation that goes to registered rep. I'm going to come back to just a second on the customer experience. In the Q&As that the SEC has put out, they've actually put a focus on that client experience and client contact space. So we've heard this reference before in our careers called the hire me conversations, H-I-R-E, me conversations. I'm on a golf course, I'm out to dinner, I'm talking to a prospect, right? Am I providing advice or am I providing education? Advice has implications and obligations under Reg BI, right? Education, not so much. Right? When does the conversation become a recommendation? Right? If we're saying to somebody, hey, I'd like you to come and talk, I really want to talk to you about your investing in one of these three areas, and maybe in these particular products, I think it's really going to be great. Let's have a conversation. You just tripped over the edge, and maybe you're in violation of Reg BI, depending on what you've done before or after. If the conversation is more like, I'm moving from one firm to another, or it's about retirement planning, or it's about minimum distributions, for example, and contribution limits, well, then you're not. So we've heard about this before. What's the trigger in the securities laws about this? It is when there is a call to action, right? That's what forms the recommendation. It could be to open an account, it could be to engage in a transaction. And when you get more and more specific, you get closer and closer to the line. But that's just an example, one example on the customer experience piece. Next slide, please. So the next piece we speak to, hold on, I have to deal with something on my screen. So I'm not going to go through all this. This is when we talk to firms, we speak to, all right, from an operational perspective, what has to change, right? What do you need to be focusing on? Because technology and operations oftentimes drive the firm, right? It goes to what you can offer and deliver, right? It also, very importantly, goes to supervision and compliance, which we said that we weren't going to spend a lot of time on this, and we really haven't so far. But if you can't deliver on the supervision and compliance aspects of this, as both an individual and the firm, particularly the firm, then that's the focus of the SEC and FINRA. And Lyndon's going to get into that a little bit more when we talk about the regulators. What I will say about this slide is to look at the middle box, right? The product and compensation structure development, because here you get a chance of where this comes home to roost, right? What all the other firms are doing is important, right? Developing new products, amending new and existing products to be compliant with the Reg BI. So what clients will end up getting will be different from a product perspective. Also, which products, right? Best interest product shelf rationalization. What exactly do they buy? Will they have to offer? And there'll be a level of due diligence we have not seen before. We're going to come back to AI Insights because of something they do here on the due diligence level, and it's something that firms are going to need to spend more time doing than they already have. Marketing reviews and the like. There's also something worth you taking a look at just on the box all the way to the right at the top on future sales practices and strategy. Training. Training has got to be a big deal in here. It's been highlighted by the regulators. And also, if you look at that second to last bullet, developing sales structure goals, incentives, that's really compensation, right, as we go to. Next slide, please. Okay, so what else? Again, so I'm not going to spend really any time on this slide other than to say that these are like give you an idea of the implementation issues and decisions and to-dos, right, as a result of Reg BI. I'm not going to take you through risk governance, operations and tech, and compliance and supervision. But again, given this audience, if you take a look at the bottom left box, business and financial, again, it goes to compensation models. Even with respect, and I shouldn't say even with respect, I should say perhaps among the hardest pieces is recommendations of rollovers versus educations of rollovers. That is a very tough line to walk. And so far, what we're seeing among our clients is that they're not walking it. They're not taking the view that rollover can be done in only an education setting. That to provide, well, you know, you might want to do this or do that, and here's what you might want to think about, because the conversation almost naturally, as a result of the client, moves into the recommendation space very quickly. Well, what do you think I should do, right? So that becomes a recommendation when you answer that question for the most part, right? And so it becomes then starting to look at what's in the best interest of the client. Well, we have more products and different kinds of products to help you with, more individual service, different things. You may end up spending more, you are likely to end up spending more money, right? But there's a conversation that ends up meeting Reg BI there where the training will have to come in. So that box is something that's sort of the everyday of what happens. None of this happens without regulators. And so if we go to the next slide, and Linda, maybe you can take us through sort of what the regulators have said and told us beyond the adoption of the rules themselves and the guidance, but maybe you can take us through this a little bit.
Happy to. I just wanted to back up for a quick second as you're looking at the lower left-hand corner discussing compensation for products. we tend to think of compensation being how much I'm getting as my salary or what my bonus is going to be, but the compensation issue also goes to the firm, and I think this really comes into play when you're looking at alternative products, where the firm is making money with an affiliated managing member or GP that's actually sponsoring this new product. That's creating a conflict and a conflict that needs to be disclosed. So think about compensation as, again, follow the money, because wherever the money goes is creating some kind of a conflict. So going on to talk about regulators and sort of where they are today. The most important bullet on this slide is the implementation deadline for June 30, and it doesn't mean that you can sort of wake up on the 29th and say, okay, what's going to happen here? The regulators are already talking to firms and asking what's happening and what are you doing today to get ready for Reg BI? And they're not sanctioning firms because they can't, but the expectation is that that progress is in the works, that each firm is looking at what it needs to do in terms of policies and procedures, what they need to do in terms of books and records, and most importantly for you all, is what kind of training is going to happen, and how are you going to change your interactions with your clients, because this is not just triggered, as David was saying, at the prospect level, but it's also triggered throughout the client relationship at specific points. So again, I think what's really happening here is there's a shift in the regulatory world as a result of this to much more focus on disclosures. And again, it's about giving the client information so they can make a choice on an informed basis. We're certainly seeing it's much more disclosure on the broker-dealer side, and it's much more documentation required both on the broker-dealer and on the investment advisor side. So that's another way that regardless of which hat you're wearing at the time that you're working with a client, know that it's going to mean, oh, what a surprise, more documentation. The regulators really like that. So as I said, regulators are already meeting with our clients. The expectation is that by July 1, this whole process is in place, and you have the documents that are created that you need to give to clients, so that when you're talking to prospects on July 1, then you need to be aware of what the triggers are for being able to be sure that they get follow-on documents. So let's move on to the next slide. And what's happened is, next slide, thank you. When the DOL rule came out, the states all sort of woke up and said, well, if the Department of Labor is making requirements of investment advisors and broker-dealers, maybe we should be looking at this too. And I think states really began to think about the fact that why is it investment advisors have fiduciary responsibilities and broker-dealers do not? And most importantly, do retail clients understand what that really means and what that means in terms of a registered rep's responsibility to them versus an investment advisor representative? So they've gotten really active, and we have a number of states that have proposed their own fiduciary standard for anyone in the financial world. So, for example, Massachusetts has passed a regulation that applies the fiduciary rule, the fiduciary conduct standard, which is, again, higher than the best interest standard, to broker-dealers, investment advisors, and anybody provide anybody selling commodities or insurance products to retail clients who are residing in Massachusetts. And this is keeping everybody very aware, because if we have Massachusetts doing this, and then we have Ohio doing this, and New Jersey and Nevada and other states with different standards, it's going to be really difficult for firms to manage what standards are really necessary where. So I think this is going to take years to work out. We're going to see lots of court cases on this about who has jurisdiction where. But just so that you know, there is talk of states making regulations that affect this that are already being challenged in the court. And there's a lot of hope out there that maybe the regulation best interest is going to go away. It's not. It's here to stay. It's done. And just assume this is going to happen, and we get to watch these court cases go on over time.
So I'm going to add a couple of things just to that really quickly. One, at the time that Massachusetts actually adopted its rule last week, it actually gave way, meaning it sort of backed away a little bit from pressure and saying that it would not apply the rule to commodities and insurance, by way of example, making the statement that that they are not securities. But interestingly enough, that was not in the rule itself. That was in guidance that was issued by the Secretary of State's office. So even on the day or the week after they adopt the rule, right, there's still more going on in each of the states. So we hear often, well, then should we not do Reg BI compliance and supervision activities and implementation as we wait for it to settle out on the states? The reality is that about 90% of what's been proposed in the states and adopted in Massachusetts will be complied with by adoption of Reg BI, and essentially where the states happen, there will likely be the ability to tune what we do in each state to comply with both. It is not the case right now as we live. States have their own blue sky laws and their own. Mostly they are duplicative of what goes on in the mostly the federal rules. But there are times where we need to pay attention to what goes on in the state. We see that with confidentiality and privacy as well, and yet we're able to do it. Okay, the interesting thing for me as a practitioner for such a long, in the business for such a long time, is to watch our clients essentially being summoned to having conversations with the SEC, specifically about how ready they are. And it's not over coffee and donuts, right? They're a lot tougher than that. Right, next slide, please. Products. So at the beginning, I was talking about conflicts, compensation, and products. There's not much more I can say now on this slide than what we've been talking about throughout, that essentially the words product rationalization, what are we offering and why are we offering it from a firm perspective, and then from the registered reps perspective. That's what it really comes down to. So the product shelf and approval reviews, the due diligence, I love a firm, AI Insights, to help with something like that. Then I come down, then once that's done, it's both and it's looked at in a bunch of different ways, by the way. So you're looking at products from the asset class or type of product, and then the specific product underneath, all right? We're looking to document why we're doing each of those things, what our review is like, essentially a due diligence review, right? And then we're seeing that there are changes that are as a result in the product universe as a result of Reg BI. Level revenue among products, a closer and almost a different review of advisor sales practices. There are various tools to be able to weigh the suitability factors, automated systems, essentially to make them agnostic to compensation, the selection of a product to compensation. Move to the next slide, please. Again, this really goes to the nature of what is product rationalization and what we've been talking about. Now, clients have already been, are already more educated. They ask more questions around fees and conflicts. We've seen that start with mutual funds and is spread to virtually all other areas. This rule is really a sort of a codification or an adoption of that approach. Again, it goes to both a formalization of the process to determine which products are added to or remain on the product shelf, and which products are being recommended by individual FAs. You'll see a process which we help firms go through. Focus on number 2 at the bottom. So there are a number of factors, qualitative and quantitative factors, which we actually help clients focus on as to what they should be looking at in making sure that the product should be offered or not, and even the specific one. Move to the next page. You'll see in the middle of that page an example of some of these factors, right? So the quantitative ones, performance, fees, risk, fund average. The qualitative ones, risk, standard features, differentiated features, service levels. So, those are all factors that are considered also in investing in AI, frankly, right? When we look at alternative investments, when we look at even standard investments, what are we thinking about? Fees, liquidity, transparency. What are the underlying investments? Risk, the time horizon, track record, minimum investment, things like that. Okay, move to the next slide. Again, this is really just trying to show the areas of firms and rep practices that are impacted on the left, right? The areas that are impacted, right? Supervision, compliance, technology, and how they hit. And then what are the sort of the real focus and the real keys? If we just stay at the top box on the right to get a sense of what we're talking about, right? So there's a need for firms and to train, and for individuals like yourselves while you're part of this call to learn about Reg BI. What are your obligations and the requirements? The rollover conversation, the SEC and FINRA mention that more than almost anything else, honestly, as examples of when a recommendation occurs and weighing risks, benefits, costs, etc. Redesign of impacted program materials, including scripts. So you get a sense that in every area on the left, there are very specific impacts on the right. Again, if you move to the next slide, it's the same idea, right? Focusing, if you look at the top left, firms should consider whether new or existing products align with the intent of the best interest standard. We have talked about that at great length. There's the notion of monitoring, disclosure, compensation on the left. Down in the middle, it's the disclosure requirements as it relates to fees and costs, right? And then over to the right, it's sort of the permissible products and services. And if you look at the wheel in the middle, it addresses how those are getting to. Move to the next slide, please. We're trying to pick up the pace given the time. AI products. I don't know, Linda, do you want to speak to this a little bit more in depth?
Yeah, I just think one of the keys that we are seeing already, even prior to Reg BI, but it's going to be even more after Reg BI, is what kind of due diligence is being done, and we are seeing an increased use of alternative investments, hedge funds, and especially private equity funds in the retail market, and we're seeing the SEC saying, you small investment advisor, do you really have the sophistication to do adequate due diligence? And how do we know that your client really understands what you're recommending for them? So I think the emphasis should be on due diligence and ensuring that the client is sophisticated enough to understand what the risks are, the illiquidity, and again, is this really a suitable investment for them? And then we go back to this question about monitoring, and are there other investments that could be obtained for the client that are at less cost to the client? And again, as we go back to the compensation, if this is a fund that an affiliated entity is sponsoring, how does the money flow, and is that really being disclosed, so that the client again is consenting with adequate information to really understand what's in front of them. So I think be very careful about recommending alternative investments in the retail market from a regulatory risk basis, and be sure that you've covered the ground in terms of due diligence, looking at costs, looking at other possible investments, and client sophistication. Anything you want to add to that, David?
No, I'm mindful of the time. Linda, why don't you sort of take us home with just a quick run through of the next two slides, which really get to the disclosure piece, which we haven't spent much time on. But if you could just run through that, and then we'll take some questions, that would be great.
So customer relationship summary is referred to as the CRS, and it's a standard new disclosure document that's required of both BD, broker-dealers, and investment advisors. And it's 2 pages. It's geared for the retail client. And let's go to the next slide. Again, this is the hope that clients will make decisions with on an informed basis. And the delivery, the reason we're going through this with you is the delivery of this document occurs at the time the client is a prospect on the broker-dealer side. If you're making a call to action, as David referred to, it goes to prospects when you give them the ADV 2A on the investment advisor side, and then it's delivered to the client on the broker-dealer side throughout the client relationship at trigger points, when there's a trade, when you're recommending a trade, changing account types. We've gone through this here. So this is just a quick look at, this is going to change how you are interacting with your clients, and the question is, who delivers this document? How's it delivered? How do you prove it's been delivered? So that's the sort of quick and dirty on the CRS, and it looks like we've got several questions.
So,
go ahead.
yeah, I see them, but I don't think we have time for all of them. I mean, I hear
David,
someone trying to say something.
Jen. Yep, thank
Hey,
you.
Jen.
This is Jen. Thanks for everyone for sending that the questions over. And if you'd like, I'd go through. We did receive some questions in the Q&A. If you want to read those, and then there are also some in the chat that I can get to once you've gone through a couple on here. If you want me to start with the first one,
So I see them. I don't know if everybody sees them. If you do, just in the interest of time, I can try and blast through these, because some of these I think all of them I've seen before. Would it be helpful if I sort of?
Yeah.
Okay, I'll start with the first.
Yeah.
The first is easy. Hand them this deck.
Oh, you know what, David? David, all of them can't see the question, so let me start. Only the panelists can. So, what can managing broker-dealers, product distributors do to comply with Reg BI and assist our broker-dealers and RA partners?
So, from a product perspective, we've spent a lot of time on this already, and I would say that to turn back to this. But in short, it's the notion of that product rationalization. So why this product and not another? Keep in mind also that we have to consider that both the broker-dealer and the reps have to consider alternatives, reasonable alternatives. The distributors, product providers, if you will, are going to have to go through a process, a very rigid process in each case, or maybe not rigid, I'll call it defined, on why this product, why not others, and essentially breaking them down into the factors that I mentioned before: cost, time horizon, risks, service, and all the others. And then that will narrow it down to the reps, who, when they consider their individual clients, will do that narrowing again. There are tools to help the managing broker-dealers to go do this. There are firms, AI Insights being one, I mentioned a few times, who can do this. So there's a whole approach to this, right? And I think a lot of it is already in the deck. Linda, you can take the second one. I think we should read it, though.
So the second one pertains to surveys that are being conducted by the states regarding readiness for Reg BI, and this is happening nationally, and it's of both state and SEC firms. I think the states are looking at this. They're planning to do a before and after survey to see if state registered firms are also beginning to comply with Reg BI, and I think the states are using this as a means of determining if they're going to require this as well. And it is not possible to opt out. If you've gotten the survey, you've got to respond to it. David, you want to take the next one?
Sure. It says, should broker-dealers and advisors have product choices in a particular asset class? Is it acceptable from a Reg BI perspective to only have one product choice? So I'd ask the question in response, does one product achieve all clients' needs? The products that are offered, the product that is offered to the client has to be in the client's best interest and service both their needs and also be suitable for the client. As a matter of course, it's rare. I'm not certain I've really ever seen only one product in an asset class, because how do you offer that to everybody? How is one thing good for everybody, right? Next one, if you are a captive broker-dealer and only offer products by the affiliated sponsor, everything is inherently a conflict. Is it just about disclosure at that point? So the short answer to that is no, it's not just about disclosure, right? The notion of a proprietary product is it has to measure up against the rest of the world and see if it's, quote, a reasonable alternative, if there are reasonable alternatives. That also means that the terms of the individual products need to be reasonable when measured up against the rest of the world. So is everything inherently a conflict? Yes. Is it only disclosure? No. Some of those points about proprietary, some of the economics of proprietary products may change or are likely to change. Now, the next one I'll take is also because it's easy. Are accredited investors considered retail? Yes.
Retail means a person, a natural person. So, but investors within a private fund are not. They don't have to get the Form CRS.
So it's really who's receiving the advice.
Yeah.
And also that professional investors, registered investment advisors, for example, if a client of yours is a registered investment advisor, that person is not subject to the rule, right?
So that go to the one about family office accounts, because that's the same question.
Are family office accounts considered covered investors for Reg BI purposes? Go to it, Linda.
I believe if it's not a registered family office, that I think that Reg BI only applies to today only applies to SEC registered investment advisors and broker dealers. So
I agree with that.
Okay, good. Thank you.
So if there are rules out there or registration requirements, right? Generally speaking, those people are deemed to be, those entities are deemed to be able to take care of themselves and are not deemed to be retail, right? I can see that there might be an exception in the way that certain family offices may be structured. Is it a family office of one person running the show but falls outside of the registration requirements of states and the federal because of the number of clients or the amount of assets? So we're giving you a sort of a blanket answer, but it's possible that there are exceptions.
Is it expected that the Reg BI or CRS documents be individualized per each representative? And that is no. It should be, there is one Reg BI for each broker-dealer, one CRS. The CRS is for the broker-dealer, the CRS is for the IA. And that is what each representative gives out. But if a representative has personal conflicts, they should be disclosed to the client at the time that the recommendation is being made, but that can be done orally.
I'm looking at the clock. Should we finish these?
Yes, I think we should. Let's finish these last couple of questions, and I have one from the chat side as well.
Does this apply to managing, I went down to the end because my eye took me there. Does this apply to managing broker-dealers that only work with wholesalers? Again, the focus is on retail, but the rule will nonetheless still focus on wholesale. The provisions of the rule will upstream and downstream to almost everybody in the industry. But its direct application is to those who focus on servicing retail investors. But if you're a wholesaler, let's say, and you have to deal with firms that are taking on your product, you're going to have to make some changes to how you do things, to the information you provide. So does it strictly apply? No. Does it apply by implication in how you'll do your business if you're a wholesaler? Yes. Does electronic delivery of the CRS disclosure require e-delivery consent by the client? And is this the same for prospects and existing clients? Linda? I got this if you don't.
Yeah, I think that broker-dealer rules are a little more rigid on this than the IA rules, but I think yes.
Yeah.
But you can't do it for prospects.
Well, I mean, you actually can do it for prospects, provided you, if you will, you step through the hoops first that allow you to deliver something electronically. So, for example, just by way of example, you need to know that they have the equipment to be able to get it. You need to know that they have you need to know that they have the sophistication and ability to do it, and that is typically done through an enrollment process for electronic delivery of anything, and those rules still apply.
So how do the new rules impact existing managed money clients? If they're retail clients, natural persons, every single client who's a retail person has to receive the Form CRS by July 1st, and then thereafter, on the broker-dealer side, when triggers are hit and whenever there are changes to the CRS on the IA side. Or when you're changing account types, strategy, et cetera. Wow, I think we answered all the questions.
Well, I have one, Linda, I have one more for you. Is it a fair comparison of a non-traded REIT and publicly traded REIT using the alternative comparison under the CARE obligation?
I'm sorry, could you repeat that?
Sure. Is it a fair comparison of a non-traded REIT and a publicly traded REIT using the alternative comparison under the CARE obligation?
Yes.
Okay.
So what you're looking at, I'm sorry. I was just going to say, so it's the reasonable alternatives. It's the language that's used in Reg BI, and you're looking at a set of factors. Remember, we went backwards to that. It was both qualitative and quantitative factors. And whether it's a publicly traded REIT or a private REIT, introduces some of those factors. Liquidity, as an example. Harvesting time and distribution, how long it's going to be in existence. The comparison is a favorable comparison for many reasons. The underlying assets, by way of example. But the short answer is yes, and it fits into the same analysis rubrics that we talked about before.
I love this last question. Maybe there's one more. What is the likelihood?
There is one more.
What is the likelihood that the Reg BI implementation be pushed back past June? I think you just can't count on that. I think it's going to be tough, but we've had a year to know about this. I don't think the regulators will push it back. David, what do you think?
So I don't think so either, because they're trying to get into a place with their readiness exams so that firms will hop to, right? Certainly the big ones. Also, what they've said is that, and I believe this, that they've said is that the first 6 months to a year, there aren't going to be any gotchas, right? Unless a firm has done next to nothing in the real world, right? They may have said the right things going in, but if they haven't done anything, right, there's not likely to be an enforcement action. There is no private right of enforcement by clients, right? That was removed. That was a feature of the DOL that actually was one of its procedural downfalls, right? But I think that to count on any kind of extension, you're setting yourself up for a bruising. That's how I would say it. And I'll put it to you this way. If the pace of clients that come to us to do full implementation, partial implementation, product rationalization, training, so we're helping lots of firms on both the individual elements of the rule and making it happen, as well as from soup to nuts, right? Also doing the same with investment advisors. Why do I say that? I say it because for firms that are counting on the rule being delayed, they're going to be in a population that are outliers. And I've been a securities lawyer for over 30 years, and I know that one thing that I don't ever want to be is an outlier with respect to compliance with rules and regs. That's, I think, how I'd answer that.
Thank you, David. One more. Many small to mid-sized firms are looking for free resources to help them comply with Reg BI. Do you have any templates or other resources that may be of use to help these firms? If so, how can we obtain them?
For example, look at the resources at the back of this. FINRA has a really, really good checklist, and they also have a conflicts list that they published in 2013. If you Google CRS templates, there are a bunch of them out there. There's a lot of information out there already. And the Bates website also has, Bates has created all kinds of material on this, and will continue to do so, I'm sure.
Well, that was our last question. David or Linda, is there anything else you'd like to add today?
Just where we started. Just a thank you. I love the questions. It speaks to the level of engagement by sort of the cohort group and your clients, and so we're glad to have participated. I hope that you got as much out of it as we did.
And thank you again.
Yes, well, thank you. I want to say thank you to David and Linda and the Bates Compliance for partnering with AI Insight in delivering this webinar. Also, thank you to the audience for calling in. Please reach out to AI Customer Care Team with any questions. Thanks so much, everyone, and have a great night.